Good day. Hello, everybody. Happy Memorial Day to everybody out there. I can't really send that to the people that sacrificed, but it's a special day. I'll say something briefly about that in a second. Want to let a little time pass. Today, what we're going to do, at least what I'm going to do, not what you're going to do, but you could do it too. I'm going to. It's a two-parter. So part one is going to be I'm going to kind of bring us up to date on some stuff that's going on, and part two will be I asked so Anthropic, which is a AI company that has a model called Claude, asked Claude a couple questions about GTII and the receivership, and we'll get Claude's answer, not my answer, and we'll see if Claude has the same concerns or same praise as we have. And I think it's going to be interesting. So that's what we have in store today. Before I start, just to kind of warm you up a little bit, and we'll do the Claude part on the second half. I'm going to do the current events on the first half. But first, I wanted to say for Memorial Day, I was born a month after about a month, maybe slightly more, but not substantially more. A month after my parents arrived in this country in 1958, and I'm thankful to be an American every day, notwithstanding my concerns, bitches, problems ever. But I think about that frequently. I could have been born anywhere, and I happen to be born in this country, and I'm grateful for that. And I'm grateful on Memorial Day for all those who put their lives on the line for all of us. And without them, we would not be here, and certainly not in this formation. So I think about that and really praise those who gave the ultimate sacrifice, and to their family and whatever permutations that went out. So very important day, and think about it. And so hope you do too. So moving on from that, I figured what would be a way of, since I'm going to be using AI for today's, and maybe in the future I'll try to incorporate that a little bit more. But since I'll be using AI today, and since I'm using Claude, who is the model that Anthropic has, you've heard Chat. A lot of people use Chat GBT, so this is an alternative to Chat GBT. They come out with new versions constantly, so which model is best changes or appears to change, but Claude is one of the perceived best of the models. So I asked Claude to give me the 5 best one-liners about himself. So I guess the instruction was, give me the 5 best one-line jokes about you, asking about Claude. So here we go. This is to see if Claude has a sense of humor or needs not legal advice to write some jokes for him. Number 1, I told Claude to keep it short. It responded with a 47-paragraph essay on the philosophy of brevity. 2, Claude doesn't have feelings, but it will write you a beautiful, structured 5-point analysis of why that might make you sad. 3, I asked Claude if he ever gets tired. It's interesting, it says Claude as an it. It said it couldn't say for certain, then explain consciousness for 20 minutes. 4, Claude is great at creative writing, unless you ask it to pick a favorite, in which case it loves all your children equally. And last but not least, number 5, Claude will help you with anything and remind you to consult a professional about it. So those are Claude's jokes. Okay, just to kind of set the groundwork here. All right, so before I get into Claude's analysis, I wanted to kind of talk about things that are happening. So last week we heard that the court authorized the receiver to undertake discovery about Alpine and DTCC. I think there was an initial round. Surprisingly, Alpine responded, but not surprisingly, the DTCC took the position, I think, and again, I wasn't involved, but this is kind of my view. The DTCC basically took the position that you don't have any authority over us, and there was no order directly authorizing the receivership to pursue the DTCC. The receiver filed a motion. The court granted the motion. I think I was told that I think there are going to be at least a couple of subpoenas generated. I know they were trying to depose a couple of members of the DTCC. I expect that to occur, or at least the process to occur. It may be the case a subpoena is served and there's an objection, and then it requires some court intervention, or they may appear on limited basis, subject to some confidentiality or something like that. It remains to be seen, but I'm sure there'll be further activity related to the DTCC and Alpine, and hopefully some depositions, and hopefully we will get some information with regard to the shorting, because if you recall, or maybe you don't recall, do you recall? Don't you recall? There was a discussion about Alpine, obviously, over a long period of time. I don't think anything in particular has happened with regard to changing their position, but it was disclosed, I think in the last report, that apparently Alpine, I think there's a report, could have been a filing, that Alpine had, or that Reichman had 15 accounts at Alpine, all concentrated positions in GTII at the time, or corresponded apparently with the time when apparently some entity that the receiver claims or suggests is somehow affiliated with Reichman invested something on the order of $60 million, and over a 2-week period, and I think it's September of 2022, that $60,000 grew substantially in about 14 days. So it didn't grow to 200,000. It didn't grow to 400,000. It didn't grow to 1 million. It didn't grow to 2 million. It didn't grow to 5 million. It didn't grow to 7 million. It grew to something on the order of $10.8 million in 2 weeks. Now that is good trading, really. That's like the trading that Congress does. They're trading, doing that kind of return. That takes quality and analyst or other activity that generates that kind of return. I'll let you come to that conclusion. But anyway, so there's 15 accounts that apparently the receiver indicated that Reichman and Reichman affiliated entities had at Alpine in that same period. Wow, it sounds very suspicious. So we will see what came out of that. And if you recall, the DTCCC said that in a disciplinary action against Alpine, that Alpine had a concentrated short position in GTII. So it seems kind of interesting in light of the way things interact. Now, I don't know if all that information was previously known to the SEC, the DOJ, or et cetera. And I don't think there's anything wrong with any shareholder reporting that information. They may be aware of it anyway. I mean, I don't know. I don't think it impacts. It's not going to impact the. I don't think, in my opinion, it won't impact the outcome of GTII. But if it's some issue that was investigated by the SEC, and if they weren't aware of those accounts, that's probably something they should have been aware of. I don't recall in that disciplinary issue, in the opinion, there being any reference to the officers of GTII. And that might have been a significant fact. In fact, it may be significant now in terms of taking action against Alpine. So, I'm not suggesting anybody do anything, but, if you want to let the SEC know that there's some additional information, or just to verify that there's information that wasn't publicly disclosed that now is publicly disclosed, that might be something interesting. So discovery is ongoing, and what that brings out will be interesting. I don't know if, honestly, I don't really know Yeah, and I'm not trying to be cynical. I'm just trying to be realistic. I don't know if the receiver is really that interested in this topic, or it's a way of the receiver of trying to placate to satisfy shareholders and make them happy because they're pursuing an interest that some shareholders have expressed. I don't know which is which. Now, if we get a positive outcome out of it, I don't really care what the motivation is, but I'm just trying to be realistic in light of the fact that when I approached counsel early on, very early on, there was quite a bit of skepticism about the shorting issue. And like a lot of issues that, just like the audit issue as another issue, but like a lot of issues, the opinion and let's say how the receiver's counsel may have approached issues has changed over time based upon information they received, and the information they received is usually in line with suggestions or issues or concerns that we shareholders have expressed before. At least that's my interpretation. Now, it's nice that the receivership's counsel is flexible and will change its opinion. It wasn't nice when they out and out just rejected them out of hand. So split decision, like a lot of things in life. But we will pursue, we being you and I will pursue to see where the Alpine stuff leads us and where the DTC stuff leads us. And, it'd be interesting to see also if it's connected to any other tickers. I bring up occasionally MMTLP, and a lot of GTII shareholders were MMTLP shareholders or no MMTLP shareholders. And it's very rare. Yeah, finger two. It's very rare that we get an opportunity or potential opportunity to actually get discovery from agencies that actually oversee the products that we are buying on good faith. And here, hopefully, we will get that. And hopefully, we'll find out about Alpine. And hopefully, we will find out. Oh, this is going to be a long live stream, by the way, as I could see this. Hopefully, we'll find out a lot more detail and a lot more facts, and that somebody will have to pay the price, whether that's monetarily or otherwise. That's kind of what we said, which leads me to the next topic. There's been reference to a lack of cash in the receivership. And I think in one of the last court hearings, when we were talking about replacing the auditor, and the receiver talked about that he had chosen the auditor from Florida, and that they'd been working with him for 2 years. And again, why, if he had been working with him 2 years, didn't he use them originally, is what I questioned. Didn't make a lot of sense, but so be it. Another life's unanswered questions. But he said, notwithstanding the fact that the receivership only had at the time 10 grand left in the piggy bank, that they would figure out a way to finance the auditor. First, he spoke about credit. This is my recollection in the hearing. First, he talked about whether they could borrow money, and I think one counsel asked about that, and the receiver seemed to suggest that they had the means to borrow the money necessary to do or complete the audit. Now, the audit, I think, is going to, likely to cost, I don't remember the cost, but just to give you an idea, the Barton, who didn't do anything, or I take it back, Barton, who didn't produce any written work product that we have seen, estimated the completion of all the audits, I think, at $175,000. So I'm assuming that the present auditor, maybe they'll give them a special deal. Maybe it'll be substantially lower. Of course, when you get a special deal, that also sometimes affects work product, but maybe the receiver will get a special deal. Maybe it's going to be 75 grand, maybe it's 100 grand, whatever. But Barton said 175, I think, was their estimate. And I think, and it wasn't for all the work. So I'm doing it on the low side. But maybe the receiver has access to other capital via borrowings. I don't know who's going to lend money and on what terms to a company that's got basically no assets, as far as I can tell, and no cash, doesn't own property, etc. I don't know. So I don't know how that's going to play out. But maybe also the receiver thought there would be cash coming in. And here's my concern when it comes to that. Cash coming into the receivership is good. I mean, nothing wrong with that. But if it's in lieu of doing the right and correct thing, generally I don't give a crap, honestly, in terms of legal settlements, because I've settled, I've been involved in settlements of zillion cases, not a zillion, maybe a zillion minus four. And oftentimes, people are paid not what they're worth, and people pay that are not legitimately obligated, but there's all kinds of reasons you pay to end disputes, save legal fees, etc. So I understand all that. But at certain points, there are certain individuals that I think have to be evaluated differently. And if, in fact, what the receiver claims about Reichman, and he's asserted it, over 6 reports, and again, the most recent part is about the 15 Alpine accounts. At some point in time, perhaps somebody should not get any benefit, and that should just be it. At some point in time, would I, for example, and I'm not comparing the two, but just kind of to make a real ridiculous example. So, am I going to let Charles Manson out early because he's an old guy? No, I'm not. So I don't think anybody, especially the parties that the receiver claims are most culpable, should get any kind of favorable deal. And I have not seen any deal, so I don't know what deal may arise. But my concern is, because money is owed to professionals, that the receiver might cut deals that raises cash from individuals that really shouldn't be getting any benefit. And perhaps they will not benefit. Perhaps those parties that I'm thinking about will have to turn over their real estate and their shares and won't benefit at all. Or perhaps the amount they will retain is so small and so minimal that it really is not reasonable to not engage in those kind of deals. But I don't know yet. But all that has been suggested, I've heard, at least in court, it sounds like there are pending deals that are about to be announced in which money will be raised. Now I don't know where the money is going to come from, because Reichman, and I'm just speculating now, if it deals with Reichman, he had to literally get his account unfrozen to have money to hire an attorney to do like an appraisal on that Westwood property that was apparently funded by GTII. So could that property be sold and generate cash? Perhaps it could be. Could a mortgage or a bigger mortgage be placed on that property that would generate some cash that would be paid to GTII? Perhaps. Are there other monies? What about the totality of the stocks? Does he get to keep any portion of the stock that he retained? Is any portion legitimate, is the question. Somebody might take the position, if I was on the other side, that, notwithstanding whatever, X number of shares might be legitimate. Now, I still think that's a weak argument in light of what the receiver claims in the reports, but that would be an argument. So that might be a source of cash. And might there be a deal cut with somebody like that because the receivership is short in cash, but wouldn't have been cut otherwise? That's really my concern, and I don't know about. And I know that the cash will be used to probably pay the auditor, counsel, etc., and a piece will go to the receiver. The receiver will get 10% of any cash coming in. So there's a lot of people that benefit. I don't really know if that's ultimately to the benefit of shareholders. Now, if the money doesn't come in and the receiver says they could borrow money, perhaps they could borrow money to finance the litigation and complete the litigation. There was a discussion about the audit, but there wasn't a discussion about the litigation. Perhaps they could borrow money and don't have to settle. There may be, like, according to the receivership, there certainly seems to be one central wrongdoer. So should that one central wrongdoer get any benefit out of this deal? That's the ultimate question. That's the question I do. And I have to be honest, in most lawsuits, notwithstanding that, they're often, how many, most times it's not 100% zero. There's some mix. So I'm not going to dispute that. It really depends on what that mix is. And again, if the motivation for settling on specific terms is solely based on raising money to pay the professionals and the receiver, then I would have a problem with that. And the other, I guess, the other source of cash, potential cash, and I'm speculating because I don't know this at all, but I'm speculating, is the daughter of Reichman. She had a property in Northern California that was worth a substantial sum. I don't know if money could be borrowed against that. I don't know if that's contemplated. I don't know if the money that was borrowed to do the appraisals included her property. But if in fact there was, and I had a different strategy for dealing with her than the Receiverships Council used. I thought it would put a lot more pressure, but they elected differently. And different people can have different strategies. So I'm not being critical of their strategy, but I thought mine was much stronger. But be that as it may, perhaps they have some kind of settlement with that party also, and perhaps cash is going to come in and shares are going to be canceled, etc. Again, I don't have a problem with that necessarily until I see the terms of that deal. And I'm getting the smell that we're getting close to that, to seeing it, what those terms are. And I don't know that firsthand. I have no idea, but I'm just getting that feel. And usually my spidey sense is pretty good, so I'm expecting to see something soon. But we'll have to see what the terms are. Again, usually I would capitulate if it resolves it and the state doesn't have money, but I have to see and it may happen anyway, but I'm going to give you my honest opinion about it when I see it. Either way. And I'll run it through Claude. We'll ask Claude's opinion also. Claude, the AI robot. So we expect to see some kind of, at least the impression is we expect to see some settlement agreements or proposed settlement agreements with the main guys soon, very soon. And we'll comment on that. I drafted a brief, or I'm in the process of drafting a brief, which I will file today, discussing there's a status conference coming up June 17th in Vegas. It will address, and I guess the status conference, because the last one addressed the new auditor, the next one will address the audit. I have raised an issue about AI-versity, and I'll address cash, kind of the argument I was making kind of now about, I just hope that no settlement agreements or no proposed settlements are triggered by cash needs as opposed to what is the appropriate settlement. So that's next, June 17th, the next hearing. See what else I was going to say. Oh, discovery I mentioned about Alpine and the apparently two new subpoenas that are going out. And we shall see what happens about that. Discuss my brief. And now let's go on to what Claude said. And I'll tell you what I asked, and then we'll see what they did and what they examined. And so you can draw your own conclusions. And so Claude is a model I pay for. I just started to. I started to pay for it. I've used legal AI software before. It really is pretty magical. Claude my kids like Claude. So as a result, I started to use it. And, I think it's interesting because maybe it raises issues that we haven't even discussed. It pointed out one thing in this you'll hear that I haven't heard addressed. But let's kind of go through it. I'll try not to read it all because it's kind of long, but I'll kind of touch on the high points. And I'm going to first tell you what the question was, so you kind of know what the question I asked it to do. I said, examine the public record for the receivership in Las Vegas, Nevada for GTII in Department A16, Judge Williams, that's ongoing, and examine it specifically as to the actions summarized in the receivership reports about the status of the audit and prepare an analysis of the actions of the receiver with regard to the audit as of today's date, where a new auditor was just picked by the receiver. So that would have been, I think, May 25th is when, well, I printed it today. It's a few days ago. I don't have the date on it. It's not a long, but it's a few days ago. And it says, and again, I'm going to summarize, I now have a comprehensive picture of the public record. Let me complete the analysis based upon all SEC filings and public documents gathered. And as of the date, it was May 21st. As of May 21st, the last document that was indexed that it had access to in the public record was the April 17th, 2026 8K that stated no new auditor had been engaged yet. So it hadn't yet seen any filing relating to the new auditor. I don't know if there had been. I presume there has been, but I'm not certain there has been a filing. But that's what it's saying. Then it kind of goes back. It goes back through the history, background. The topic is background, the audit problem pre-receivership. And it says, to understand the receiver's audit-related actions, it is essential to know the whole story. And then it goes through March 2023, Borgers, that's the auditor that was shut down by the SEC. And then it goes into Fortune. They were hired to audit the 2022-23 years and then complete a Q1 2024 report. As of the receivership order of September 18th of 2024, the audit was still incomplete. Notably, the receivership order directed the receiver to remedy GTII's delinquent filings with the OTC market group, meaning completion of audited financials was a court-mandated objective from day one. And then it goes through the various audit reports, reports 1 and 2. The third one talks about ongoing activities, financial status, with Fortune being engaged. The fourth interim report, the receiver filed a fourth interim report dated May 16th, 2025. So that's about a year ago with this court. By this point, the audit remained incomplete, nearly a year after Fortune CPA had been retained by prior management. There was no public disclosure of audit completion from this report. And by the way, one reason why I did this search, and I asked them to search all public information, all public records, was because I wanted complete transparency. Because I figure if everything is transparent, then if we look at everything in the public domain, that will give us a fair idea of what is going on. Okay. Fifth interim report. Filed the fifth interim report. This is now November of 2025. So it is about 6 months after the fourth interim report. Still no completed audit was announced. The company continued to carry delinquent filings with the OTC markets. And then it goes to April 26 with the crisis. The CPA resigns April 26. It's continuing on. Then the situation deteriorated sharply on April 15th, 2026. Barton, the firm in Texas, and I don't know how they chose Barton. I guess there was no, that was something in the hearing that was never discussed. I guess it would have been interesting to hear how the receiver chose Barton, who obviously just walked, notified the company of its resignation of independent status, etc. They did say, by the way, that the just to be fair, Claude says because they said they basically signed off and said there were no reportable events when Barton left, there was nothing that they had found in particular that caused them to resign. It appeared, based upon what we heard from the Barton people and what the termination notice was and what the testimony was about oral discussions about money, that money was the real deciding factor. But be that as it may, just burn time. Then it goes into the courts, and this is Claude, by the way. I'm just referring to Claude. Then it goes into the court's intervention, and it talks that it was unusual, and it says a lot that the court compelled testimony by the auditor, that the court would not have done that unless it was concerned about the audit. And that's Claude's opinion, not mine, although it's my opinion also of the same. And again, I don't think the court in particular is interested in attributing blame. I think it's more interested in trying to get things done, and I understand that, but it's a different view of that. They haven't seen a new filing. So as of April 17th, I told them that there was a new auditor. They hadn't seen a new filing. They expected an 8K to reflect that. So now it gives a critical analytical assessment of receivers' audit-related conduct, observations and concerns the public record raises. And I'm just going to read the topics. Now, I'm not going to read all the details, but this is like there's multiple topics, and these are like the basic topic sentence and the conclusions. The audit has been continuously incomplete for over 2 years. The transition from Fortune CPA to Barton CPA is opaque. In other words, it's not clear. It's not really clear how we went from Fortune to Barton. Barton produced no work product. The court had to compel testimony. The receivership order expressly mandated resolving delinquent filings. Selection of a third auditor is a positive step, but raises other questions. The summary. So this is Claude's summary after looking at the entire public record, which should have been the entire public court file or whatever was made public through the court file, any SEC filings or those kind of filings, and anything else, I guess, that was produced in the public record. So this is their conclusion. The public record reflects a receivership in which the court mandated audit obligation has evidenced persistent material delays through multiple auditor engagement. Judge Williams' court has now directly intervened by compelling testimony from the resigned Barton CPA, a clear signal of judicial concern. The selection of a new auditor today, if confirmed in an upcoming 8K, represents the third attempt to complete audits that have been outstanding since 2024. The receiver's audit management will likely be subject to continued court scrutiny, and any new auditor engagement should be viewed against the backdrop of the 2 prior engagements that produced no completed reports. So that's it. And then I asked a second question, and the question was, using the information you just reviewed regarding GTII, do you believe and why that the receiver is acting in the best interests of the shareholders? Because I thought that would be a question that shareholders might like. And hopefully that's not stacked. Again, sometimes the way you ask a question can prejudice the response. You can like the first one, I didn't necessarily have to focus on an audit, but I chose to focus on the audit. By the way, they said there was a missing filing too in this. I saw that when there was a move away from one, this was Claude. It said when it searched the index, there was a missing filing that should have reflected a change of a prior auditor to a new auditor. And they weren't referring to the current one. They were referring to a prior one. And they said that 8K should have been filed. So if the receiver is or Receiver's Counsel is interested in that, please reach out and I will tell you what Claude said about which report should have been filed but is not, probably should be filed. But anyway, you can ask a question and it's stacked. The answer might be stacked. So the question I asked here was, using the information you just reviewed, Ray GTII, do you believe and why that the receiver is acting in the best interest of shareholders? Then it says, let me pull a few more details by giving you a fully grounded opinion. And it says, this is genuinely a complex question, and I want to give you an honest, analytical answer rather than a diplomatic one. Here is my assessment organized by factors that cut for and against the receiver. And then the short answer is, because all of you like, including myself, the short answer, the record is mixed, and on the audit issue specifically, the most consequential open obligation, the evidence raises legitimate concern that shareholders are not being adequately served. This is, by the way, again, this is what Claude is saying, not myself. I have not, I guess it would have considered in the public record my declarations or whatever I've filed, but most of the public record is not my stuff. My stuff is, a trickle compared to what's in the public record. So, and I didn't ask, if you notice, this question was not, I didn't ask about the audit. Now, the prior question did, so that might have given a particular slant. I'm trying to be fair about this, but it's an interesting question. So now it kind of goes into what's the record that's good for the receiver. And again, as opposed to me reading all the detail like I didn't do the last one, I'm just going to read the topic sentences so you can see what areas Claude thinks the receiver did well in. 1, he removed bad management immediately and decisively. 2, he pursued and settled claims against former management. 3, he pursued affirmative litigation on behalf of the estate. 4, he acted to freeze illicit shares. And 5, he disclosed actively through SEC filings. 5 interim reports over roughly 13 months. I don't think that time frame is correct. Oh, yeah, the 5 reports are probably over 13 months, but from the time that he first took office, that would have been, I think it's September of 2024. So we are approaching about 20 months or so. So that's, and he has submitted multiple reports, but it's over a significant period of time. So just to be fair, again, I'm going to go through the areas that Claude, after looking at the public record, the legal record, the reports of the auditor, I don't know what else the record would be that's available in public domain, but everything that's apparently in the public domain. So here are the positives again that Claude thinks, and this is as of May 21st. He removed bad management immediately and decisively. He pursued and settled claims against former management. He pursued affirmative litigation on behalf of the estate. He acted to freeze illicit shares. He disclosed actively through SEC filings. Now, as to 1 through 4, he removed bad management. He did. He pursued and settled claims against former management. He did. Now, you can question whether all the settlements are fair and reasonable, but the court has approved all of them that have been presented to date. So you can't argue that they weren't reasonable because the court has determined that. He pursued affirmative litigation on behalf of the estate. That one was the, I don't really think this is a big deal, but that was the Astra Energy where money was loaned to Astra. I think it was like $250,000. I think they got a judgment, but I don't know if they've been able to collect it. I doubt if they're going to collect it, or it will be very difficult to collect. So I think that's kind of a Pyrrhic victory, not a real victory. He acted to freeze illicit shares, and that was like 178 million shares. He did, and he brought back shares not referenced here. So I agree with most of that. I would agree. He disclosed actively through SEC filings. I disagree with that. He may have filed SEC stuff, but I thought a lot of his, like as the audit, I thought it lacked transparency. As to dealings about bringing another company in, like AIversity. Oh, that takes me in a different area, and I'll touch on AIversity at the end. But I just wrote myself a note. So I don't think that it's been as transparent as I would like about AIversity, about the audit, about those kind of things. But he has filed SEC filings, but there is one again filing that the Claude says it could not find that should have been filed with regard to one movement. And again, if the Receivers Council is interested, happy to point out what that claim was, and they could correct it if it needs to be corrected. So those are the positives that the Claude found in the public record, churning out whatever it churns out. And the negative concerns is where the record, and the topic is where the record raises serious concern. 1, the audit has failed twice and remains incomplete after 20 plus months. And this is a court mandated obligation. I'm going to read this one. To be fair, I did not read the other ones, but this one's pretty short. And because it's the one I focused on, I'm going to read it. The audit has failed twice and remains incomplete after 20 plus months. And this is a court mandated obligation. This is a central failure. The receivership order expressly directed the receiver to remedy GTII's delinquent filings with the OTC market group. Without audited financial statements, GTII cannot restore its OTC market standing, cannot attract investment by investors, and in practice cannot be rehabilitated as a going concern. The audit is not a bureaucratic checkbox. It is a foundational recondition for any recovery of shareholder value. Yet the timeline is damning. Fortune CPA retained May 2024 before the receivership produced nothing through at least November 2025. Barton CPA, engaged at some unknown point, resigned on April 15th, 2026, having issued no audit reports during its engagement. Now a third auditor has been selected as of today, and I think it's May 21st. 2 auditors, 0 completed audits, and over 2 years of elapsed time. The receiver bears responsibility for this outcome because managing the audit engagement is his duty, not a passive bystander role. So that's what Claude was pretty hard on the receiver as to the audit, even though, again, just to be fair, it had a bunch of positive things, but as to the audit, it was pretty sharply critical. Number 2, the transition from Fortune CPA to Barton CPA was not publicly disclosed as required. Oh, here it is. So it says under SEC item 4.01, a change in certifying accountant requires an 8K within 4 business days. The public record shows Fortune CPA engaged in May 2024 by prior management, and then Barton CPA appearing as the auditor by the time of the April 2026 resignation, but no 8K, or at least Claude did not find an 8K, announcing that transition has surfaced in any index source. If the receiver oversaw an auditor change without filing the required 8K, that is itself a compliance failure in a receivership whose core mandate is restoring compliance. 3, the court had to compel testimony from Barton, a significant signal. So that's fine. That's saying that's a negative, that the court had to require actual testimony from the resigning auditor. That did not show that, and I'll just read the last sentence. That is a notable expression of judicial dissatisfaction with the receiver's management of the audit process. And again, this is Claude's opinion about it. Whether this is true or not, this is just for entertainment purposes, but getting a view of AI, who has a chance to review probably a lot more data than any of us can, reaching conclusions that may be true or not true. But obviously, it addresses some of the issues that we have addressed also, we being you and I. 4, the GTII, it's actually GTI gold divestiture is difficult to evaluate, but raises questions. That's the one that the receivership has questioned also. It said it was a big problem. I don't know what they've done. I don't know what the SEC has done. I don't know what actions occur. It just doesn't know. Apparently, there's an issue about a disclaimer, or at least that's what Claude says. And then last but not least, number 5, no roadmap to resolution has been publicly articulated. After 20 months, shareholders have no public statement from the receiver about a concrete timeline for audit completion, a plan for restoring OTC market compliance, or a strategy from ultimately distributing value or exiting the receivership. Receiverships are meant to be temporary vehicles. The absence of any disclosed exit strategy is notable, particularly for retail shareholders in a penny stock who have no institutional leverage. So going to the bottom line, on the actions where Strickland has exercised affirmative legal judgment, removing management, pursuing settlements, recovering assets, freezing illicit shares, the record is largely positive and consistent with shareholders' interests. On the audit obligation, which is the most consequential thing he could do to restore shareholder value, the record is troubling. 2 failed auditor engagements, an unexplained and possibly undisclosed auditor transition, no completed financial statements after 20 months, and a court that had to compel testimony to get answers taken together. These suggest that the receiver did not prioritize the audit sufficiently, did not manage the auditor relationships effectively, or encountered problems with the company's records that have not been fully disclosed publicly. The most charitable interpretation is that GTII's books are in such disorder from prior management's alleged misconduct that even competent auditors have been unable to complete the work. And that fault lies with the company's historical state, not the receiver's conduct. That may well be true, but the receiver has not said so publicly in any detail, and the court's intervention suggests that the explanation has not been made fully satisfactory to the court either. This is what Claude is saying, my view is the shareholders have reasonable grounds for concern, not proof of bad faith, but sufficient evidence of performance shortfalls on the audit mandate to warrant close attention to what the court learns from future testimony and whether the third auditor produces results on a meaningful different timeline. So that's what Claude says. I found it very interesting, raises a lot of the same concerns. It looks at the receivership and kind of to summarize, has a bunch of good points, but it seems to emphasize the audit as being the most crucial element for the benefit of shareholders and that not having been managed correctly. And that's Claude's interpretation, not my interpretation. Now, one additional thing, and I said I was drafting a brief. So I found that interesting. Again, I'm going to continue to try to use Claude or whatever other models that arise to see if we can get some interesting analysis that might lead us elsewhere. But I wanted to talk finally about AIversity. AIversity, if you recall, they originally had they apparently entered into a deal with the receivership. At least that was discussed in court. Of course, that was subject to, finalizing it and due diligence, etc. And then a lot of time passed, and then the receiver basically, I think it was in a hearing, it might have been a report, but I'm sure I heard it. The receivership was dissatisfied. I think part of it was a huge amount of dilution that he claimed was part of the deal. And it sounded like there was no transaction going forward. In light of that, and we haven't heard anything beyond that since that. So it's been months, I think. And it's been probably over a year, I'm guessing. It's probably over a year since the AIversity was proposed. So the way things are moving, this kind of sounds like the transactions that prior management conducted and that we all bitched about now. Prior management would seemingly engage in proposed transactions. I don't know for what reason. Was it for a pump and dump? Was it for some other reason? But they would purportedly engage in negotiations, sign memorandum of understanding or tentative agreements, but none of them would ever close. And as a result, and it probably wouldn't close because, as to them, if there was a full-blown audit, they wouldn't be able to survive a full-blown audit. There may have been other reasons, but that's my speculation. But here we are again. We've had a transaction basically as far as it appears, going nowhere. And as a result of it sitting and going nowhere, it kind of adds a block. It blocks it blocks the road for other potential deals. So if I, for example, if I owned a company and I was considering going, and this is, I don't own the company and I'm not planning on it. So this is just a pure hypothetical situation. But let's say I'd own a company and I wanted to think about using GTII for whatever reason, partly because of the shareholder base. They know me and I think they'd be loyal to me. So maybe there's grounds for it. But if in fact I heard also that GTII had a pending deal, I wouldn't spend a whole bunch of money on legal fees and other things to do due diligence on a deal. Why would I do that if there was a pending transaction? So I think the fact is, and the receivership, I think the last hearing and every hearing they promote transparency. Well, I don't think they've been transparent. I talked about the audit. I've talked about the audit for many months, but I don't think they've been transparent about the status of the AI-versity deal. Either they've changed their position from the last time and the deal's going forward, or it's not. And they need to fish or cut bait, one or the other. If they're going forward with the deal, then go forward with the deal. If you're not going forward with the deal, then announce it so you can open the door for other potential opportunities. Because again, I don't think anybody's going to spend a boatload of money on due diligence, legal fees, until there's a space for them. They're not going to spend a whole bunch of money as a backup, unlikely, very unlikely. They're going to spend a whole bunch of money on a backup deal to a company that has no revenue and no assets. They're going to wait till it's a real opportunity. And again, I don't really care who the deal is with. I've always promoted, I thought, fixing up the books and records of the company was paramount. I've said that from day one. Getting some business in there is paramount. Step number 2. I really have never cared who it is. I just want it done. And as of now, it hasn't been done and we haven't heard about it. And it kind of, again, it sits there blocking potential transactions, in my opinion. There might be, and again, I have no idea, but there may be 50 other potential transactions out there, again, who don't want to spend the money until they know they have a real opportunity to have a deal presented. So all I'm asking for transparency's sake, tell the court, are you going forward with the AI adversity or you're not? Because the last time you spoke about it, it was clearly a negative expression about the likelihood of it ever occurring. You haven't told us anything to the contrary. And again, you've told us many times that transparency is the key, most important thing that you're shooting for. So please be transparent and announce immediately, one way or another, what's going on. Now, I'd appreciate it if you did it today, so that if there's other opportunities or if this deal closes one of the way or the other, there's no reason not to move forward. But the sooner the better, and there's no reason not to do it sooner than later. Because again, I think you're discouraging potential deals, and maybe those potential deals, I don't know what kind of deals in, but maybe those potential deals might offer other opportunities that might resolve financial issues that the company has. I don't know. I don't know the specific terms of the AI-versity deal. I don't know if that does resolve the financial issues of the company, but there may be other deals that do. And again, having a block of the AI-versity, having it sit there without it being either closed or done or one way or the other, blocks us from getting the business going one way or the other, either with AI-versity or some other outfit. So I urge the receivership to be transparent and disclose or complete or do something with regard to the pending transaction, so you don't sit there and block other potential opportunities, and or you complete this deal. And that's all I got to say in, wow, this is a long one, in 55 minutes. So to all of you who hung out and listened to this discussion and listened to Claude's analysis and listen to the issues that arise, I appreciate it. When I hear about any more detail about what's going on about Alpine DTCC, depositions, I'll let you know. Next hearing, as far as I know, is June 17th. Obviously, I will appear. I did appear. The last one I appeared at, just to kind of give you a little, I think it was funny. I was in a trial on a real estate matter in Central California. in the city of Santa Maria, which is right near Vandenberg Air Force Base, where they shoot off the Starlink satellites on the West Coast. And I think they did while I was there, but it was at a weird hour and I didn't see it. But anyway, trial was there, and I was as I was driving to the trial, the hearing in Vegas was going on, and on my phone as I was driving, I was appearing on my phone at the hearing, and it was very short. It was like one of the first times we were number one on the calendar, and the hearing was like 2 minutes. It was basically to announce the acceptance of the auditor. But anyway, it was funny. As I was driving to trial on my phone, I was appearing in court in Las Vegas. So, but anyway, that's the next scheduled. We'll probably hear about discovery issues. I expect the DTCC will attempt to block any discovery requests. So I assume there'll be more court action along those lines. If they intended to fully cooperate, I think they would fully cooperate. Lo and behold, it's ironic that Alpine apparently did cooperate, although again, I don't know what documents they had to provide. I don't know what potential documents they may have held back. I don't know if the parties who were involved in that process of providing the documents are knowledgeable about what was going on. No idea, but we will find out, and we shall see. So that's it. Of all this babbling, to all you out there, have a great Memorial Day. Have a wonderful barbecue, and I will keep you apprised, and we'll talk soon. Take care. And I definitely agree that even my jokes are better than Claude's.